morning, everyone. I apologize for our tardiness on starting this meeting. It is 8:47, and this is a meeting of the Commission on Minimum Continuing Legal Education. If I could quickly take a roll call. Judge Facetto?
Present.
Attorney Uri?
Present.
Judge Clow?
Present.
Judge Stewart?
Present.
Judge Murphy?
Present.
Attorney Maurizio?
Present.
Attorney Payne?
Present. Good morning.
And Attorney Pepe?
Present.
Good morning. Thank you all for coming on short notice. The first item on our agenda is review and approval of the March 7, 2024 minutes.
I'll make a
Can I get a
motion.
To approve.
Yeah.
Thank
I'll
you, Judge
second.
Clow.
Second.
Any objection? The minutes are approved as drafted. Our second item of business is a referral from the Chief Court Administrator to amend Practice Book Section 2-27 capital A, subsection B, subsection 8, and subsection C, which would expand the minimum continuing legal education rule to permit up to 6 hours of MCLE credit for uncompensated pro bono legal services. I've provided a memorandum to the committee on this issue. And Fred, if you wanted to discuss it.
Judge Pacetto?
Yes. So again, folks, I'm at a little disadvantaged because I don't have my notes, but we did receive a request from the legislature, specifically the chair of the Judiciary Committee, for us to consider permitting pro bono hours towards legal education credits. And I know that they're very keen on pursuing this. There was a question posed to Judge Bright in his confirmation hearing if he had any opposition to it, and testified that he thought it would be a great idea. I know that Judge Stewart in her renomination hearing was asked a similar question. Other judges may have as well. So that's where this is coming from. We've discussed this internally, Judge Bizzuto, myself, Melissa Farley. We thought it was a good idea under, some controlled parameters to allow credit for pro bono work. So Elizabeth, under a very short time period, was kind enough to compile some information for us. And you have the memo. So what we put together was for every 2 hours of pro bono work, you could receive 1 credit of continuing of legal education credit. So that's where we are. You were a little under the gun because if we want to get this year, if we want this to happen this year, we have to get this to the Rules Committee because it would require a rules change this week, actually, and which is why we scheduled this meeting on such short notice. The last meeting of the Rules Committee is March 17th. The April meeting is a public hearing. Then it goes before the judges at their institute on in June. So I think, we looked at all the different states. There are 21 states that currently permit credit for pro bono work. The most liberal being Florida, which does a 1-for-1, 1 hour of pro bono work, 1 hour of credit. We focus in on New York because it's a neighboring state and we have some crossovers in terms of, attorneys that practice in both jurisdictions. And that would be 2 hours of pro bono work for 1 credit. So anybody wants to have comments or questions?
Elizabeth, how much does the Florida allow up to? Because I think Judge Clow asked that question, and then we decided we needed to wait till we got on to public hearing.
To discuss it. I can tell you that Florida is a 3-year state, and so they only collect MCLE credits from their lawyers every 3 years. They don't do an annual registration. And so their rules are a little bit different. I'm not familiar with their maximum number of credits, though. I'm sorry about that.
Okay, no problem.
So I did, in the memo, I did sort of put together 3 questions for the commission to consider. The first was, should we support the proposed rule change to allow this as an activity eligible for MCLE credit? I think Judge Facetto has brought forth very good reasons why it would be a good idea for the commission to support this. It also is in keeping with the judicial branch, their pillars of excellence and their promotion of fairness and access to justice for everyone. So I think it's within the public policy of the judicial branch and the what they would like to see promoted. This is also, there's a pro bono committee that's been established. I know they've been studying the issue for many years, and this seems like a reasonable way to promote pro bono without getting to some kind of mandatory pro bono for lawyers to do. This is really a voluntary way for them to participate and to get some credit for what it is that they're doing. The second issue, though, was whether stylistically there were any changes we would recommend to the proposal as written in order to bring it in line with the way that the practice book writes things. For example, the original proposal uses both the numerals as well as the number, and that's not generally done in the practice book. So that was a stylistic change that I had recommended. And then finally, if this is passed, my recommendation would be for us to have a subcommittee look at the new rule and provide some additional FAQs on the website to explain to lawyers how it is that they would be able to do this.
Okay. Yeah, Judge Stewart.
I think you were just going to say any discussion. I do have a couple of questions.
Yes, that's.
All right. So I'm in the rather odd position of being on this commission and being on the Rules Committee and being the chair of the Pro Bono Committee of the Access to Justice Commission, which is probably why I was the person who got asked this question when I was up for renomination. But, and it kind of came out of the blue because I honestly hadn't prepared for it. I generally am in favor of the rule as tweaked by Attorney Rowe, because I would prefer to have, but I do have some concerns about, and I know that we would prefer to have this accomplished by these committees, meaning this committee and the Rules Committee. My pro bono committee isn't going to meet in full until well after the Rules Committee, and I don't frankly see a way to wrangle them in the short period of time involved. One comment I have is that the Rules Committee oftentimes refers these things out. I mean, they're not used to, they move rather slowly and they're not used to like just confirming things right away. So I'm just wondering if there's any other stakeholders other than the aforementioned pro bono committee that we think ought to look at this or comment on it before it goes to the Rules Committee to kind of preempt that problem. So that's one comment I have. And completely unrelated, but we were having a talk about the New York rule earlier before we were on the record. And I know New York requires a lot more CLE than we do. Do we have a sense, and maybe it was in your memo and I missed it, what proportion of their CLE is met by doing pro bono? And then, I'm sorry to load up these questions. What will we be doing to make sure that people aren't just saying, oh, my client didn't pay me, I want to get credit for that? So those are my questions in no particular order.
So for the New York does biannual registration. So they collect their CLE, MCLE information every 2 years, and they have 24 credits every 2 years. So it does balance out with what we have, which is 12 credits every year. They do allow 10 hours of CLE for pro bono. So this would be proportional. It would be a little bit more generous than what the New York rule is, but similar in the amount. And then they had something in their regulations that said an additional 5 hours could be earned, but I didn't find any regulations that explained when that was the appropriate situation. The rule's also written so that you need to do your pro bono through either a legal aid organization or a bar association project or something that's been approved by the judicial branch. So it's not the same as saying, well, I didn't get paid by that client. Or even I had a client who came in who couldn't afford my services. I wanted to do it for free. Or I sit on the board of the local religious organization or the board of, the library board or something like that. And so I wanted to count my legal hours for them as pro bono. This would require you to do it under the umbrella of an official organization that does pro bono work. I guess the other stakeholders might be legal aid organizations or a bar association that has a project for it. I have seen, though, when the Chief Court Administrator's Office or the judicial branch is behind a rule, that they have moved more quickly on the Rules Committee, and then after the fact let people know that we've made this change and, accommodated after the fact, basically.
And Judge Stewart, I did speak to Justice Alexander and asked if we could add this, if approved, to her agenda. Would also be last minute. She had no issue with that.
And then one other
Am I
item,
right?
Judge Stewart,
Oh, I'm sorry.
was just in New York, there is a residency requirement in that it has to be a New York pro bono program. And so that's a possibility, just to raise that issue to the Rules Committee as to whether or not they want a residency requirement for the pro bono. So it'd have to be done through the Connecticut Bar Association or the Connecticut Judicial Branch approved program rather than something out of state.
I don't see that as a problem, Elizabeth, to add that to our, because I think, it addresses concerns that it might be too loose, so to speak. We would have more control having, it done in Connecticut with organizations that we approve, the Connecticut Bar Association, bona fide legal aid organizations and so forth.
I guess just my commentary or observation on that end would be our MCLE rule is a little bit different from New York's, as I understand it, because New York and many other states have the approved requirement where we're more self-guided. So I guess I have no concern either way, and I can think of some good arguments why we might want to monitor the pro bono more. But it seems that if we were doing that, we would be sort of setting up a more robust oversight for ourselves or for someone else on the pro bono part.
I think, at least Elizabeth, correct me if I'm wrong, I thought that if we did a residency requirement, it was just making sure that, again, self-regulating, that they would do it for something that was in Connecticut, the legal aid in Connecticut, the a bar association, if one of the metro bars had a legal aid program, that they would be doing it for Connecticut residents in Connecticut.
I think that's correct. So, Attorney Payne, you're correct. Most other states have very rigorous CLE programs
Right.
where the CLE providers need to be pre-approved. In New York, the pro bono CLE providers need to be pre-approved. I think we've always taken the view in Connecticut, though, that the attorneys are officers of the court and that they wouldn't violate the rules as written. If you put an extra burden on doing the pro bono work, that they had to submit the hours to my office or something along those lines, it might discourage people from taking that as an option. So that's the only risk you take. I mean, you would get more oversight to make sure that the hours were correctly applied, but you would also make a little bit more of a burden for somebody who maybe says, well, I'm not going to bother. I could just listen and self-certify. So I think if you make it harder to do this, then you may have to think about making it harder to get your CLE credit. And that would put a regulatory burden on lawyers, and it would also put a cost on my office to put resources into that.
Right. I agree.
Yeah, that
And
wasn't.
Judge Cloud, did you have a comment as well?
Fred, did you want to go first?
No,
I'll
no, you
follow
go
up.
first, Judge. Nope, you go.
My question was this: it seems that the concept behind the proposed rule is to do something to encourage more pro bono, which certainly is necessary. But if we're trying to encourage pro bono as opposed to give people who currently do pro bono work just another way to get their CLE credits, is there any? How confident are we that the rule is as proposed would actually encourage more pro bono, either more by people who are doing it or more pro bono by getting people who don't do much to do it?
I think one thing you could do if this rule was passed, the pro bono committee in the past has done a survey along with the attorney registration, and they could implement that survey again. We got away from it during COVID, and it got repetitive, and so they did surveys for about 10 years of lawyers asking them about pro bono. We could re-implement that survey and see if there's an increase in the number of lawyers who are now saying that they're doing pro bono work.
Judge Stewart.
Yeah, I just wanted to respond. We actually are trying in the pro bono committee to get away from the survey because it had such a low response rate. And instead, I'm actually having a meeting with a smaller group today, including Chief Judge Bright, to work on listening sessions with various groups around the state. Some would be, pro bono partners at the larger firms. Some would be in-house people. Some would be the people who have won pro bono awards in the past. But what we have found, and we have a lot more research than the survey, is the heaviest, I'll call it recorded and reported pro bono work we know about is people showing up at the local library or stand down events or whatever, doing very brief. There's a lot more of that. Would amount to the 2 hours, for example, but there's a lot more of showing up at a one-time event than taking on cases for whatever that's worth. So I could see people, perhaps they would rack up 2 hours from doing one of these utility sessions or veteran session or whatever. But it might, I can see definitely that the rule as presently written might encourage some of those people who, what I would call, kind of dip their toe into like showing up at one of these little 1 or 2 hour clinic sessions, doing something more substantive, which we really want to encourage, because the main point of these listening tours is to try and find out. We got the survey, unfortunately, generated a lot of negative commentary. Like, are you guys going to require this now? Kind of, as opposed to, we're hoping from the listening tour to find out on the more positive side, what would encourage people who already do a little bit of this to do more, or what would encourage people who aren't doing pro bono to do some pro bono. So I do think that the rule as presently written and as I said before, tweaked by Attorney Rowe would accomplish some of that, to Judge Klau's question.
Thank you.
And Judge Stewart, I would just offer to you as well. I do talk to a lot of attorneys about, through the course of my day. A number of attorneys, I think, feel they don't have the right skill set for what legal aid is. And I know they have improved that pro bono website for what opportunities are out there. And so perhaps if there were more opportunities that were for discrete projects that were easier for someone to sort of scroll through and say, oh, I would like to do that one, or this one fits my skill set. But like if I talk to a real estate lawyer, they say, I don't know anything about litigation. I don't feel comfortable going in and doing an eviction, representing a tenant or something like that, because it's not in my skill set.
Well, we are, my committee's, not to go on and on about this, but my committee's sort of split in half at the moment. One half of us is working very hard on these listening tours and interviews, and the other half is working on really beefing up ctlawhelp.org, which is the site that would-be clients go on, and ctprobono.org, which is the site that a number of legal aid groups, principally SLS, got a grant from the Justice Department to display opportunities, so it makes it easy for law students and lawyers to go on and go, hey, no, this project looks interesting to me. And part of that focus would be to address your point, to have things for transactional lawyers who aren't comfortable with things that might take them into court.
Is there any other discussion?
Yeah, this is Lou Pepe, if I may. I'm afraid I must respectfully go on record opposing this amendment for the following reason. I read the rules of professional conduct to require lawyers to do both, to undertake certain minimum continuing legal education and also to render pro bono services. And I don't think the rules provide now, nor should they, that you could do one in lieu of the other. I think those are both obligations the profession has, and I don't think one should be diluted in favor of the other. And so that's why I oppose the amendment. Please don't construe my opposition as being insensitive to the objectives of the judicial branch or the hard work the pro bono committee is doing to get more pro bono services rendered. It's just I can't support it in good conscience for that reason.
Thank you, Lou.
Elizabeth, if I may,
Yes.
I'd like to echo Attorney Pepe's his comments in terms of the foundational elements of this rule. The rule itself is incredibly permissible in terms of what qualifies as CLE, and the fact that there is incredibly minimal oversight when it comes to an individual checking the box on a form saying that they performed the 12 hours. As noble and as necessary as pro bono service is, I don't think anybody on this commission would object as to the need for it. But echoing Attorney Pepe's comments, the amendment to this rule would really undermine what we're trying to accomplish from the basis of the rule. I don't see as written, especially allowing up to 6 hours of credit for pro bono, as being consistent with the prior rulings that this commission has had. I mean, pro bono services are not educational. They could, they're simply not consistent with the tenets of the rule itself. So looking at the rule and the amendment as presented, I think that's where Attorney Pepe's comments are coming from. And I would agree with him in terms of as written. I certainly wouldn't agree to having this passed as such, but I not undermining the need for pro bono. I would ask this commission, if it is going to be passed, to look at the number of credits that we're looking to allow for this. I think 6 is an incredibly generous number for legal services that attorneys should be performing within the course of their duties, as counsel and throughout the course of their career, especially during their calendar year.
The only thing I'll add to that is in order to get 6 credits, you actually are doing 12 hours of work. So I think someone who's doing this and wants to do the pro bono is actually someone who's dedicated to it, because I could easily take an online course for 6 hours as opposed to working in and helping someone on a pro bono basis doing it 12 hours. So I think it takes a little more dedication on the part of the person that's seeking those credits. And, and hopefully, it is a learning experience for the person that's doing it. The rules of evidence, especially for someone who may be a transactional attorney, someone who's not in court often, it gives them an opportunity to get out of their comfort zone, get CLE credits, and help someone who doesn't have the ability to hire an attorney.
I guess my question would be back to, the supervision aspect of it. I recognize Attorney Pepe and Attorney Maurizio's the idea of we are doing. I think the intention is to do a very good thing and to increase pro bono endeavors, but it does dilute the purpose of the rule, which was originally to, make sure lawyers are educating themselves. I do, though, recognize that our rule has a lot of latitude, so it does encompass, the idea that we would be self-educating if we're taking on something like that, or even representing a client, doing anything is always a bit of an education if you're doing it right. You're looking to see how you can do it better, etc. But I guess tracking back to if we're sort of recognizing intellectually we're diluting a bit the MCLE itself, do we want to have the pro bono endeavors go towards specific agencies that would then better be able to direct the pro bono? In other words, do we want to sort of lean in a little bit and say, hey, legal aid has really desperate needs for people, or, people just beyond the legal aid, in other words, you should get a referral from legal aid that this is somebody who doesn't quite meet our standards, but really could use a lawyer, as opposed to any attorney saying, well, I'll do a favor for my neighbor, or, that sort of thing. Do as long as we're sort of stretching things a little bit, do we want to go a little bit further to make sure the endeavors are better directed?
But I think Attorney Rowe made some suggested changes to the rule that would address that, Attorney Payne. So on the packet that she provided us on page 4, it would be afford counsel under the supervision of an organized legal aid society, a state or local bar association project, or a court-affiliated pro bono program. So there are some parameters set there so that it's not, I'm doing a favor for my neighbor or something to that effect.
Attorney Pepe, that doesn't alleviate your concerns, though, correct?
Yeah, I think those constraints are well placed, and I think do achieve what we would want to achieve. And again, not for a moment do I suggest pro bono is not important, as important, and more important than MCLE. I just have trouble supporting this because, as Larry pointed out, we jokingly refer to our MCLE as MCLE light, and I think that's because we all recognize that when we were able to finally get this implemented, we did agree to some structure that would facilitate compliance. If not make it easy to comply, certainly to facilitate it. And in the ensuing years, when the committee was presented with proposals tied to MCLE and to provide MCLE credit for other kinds of endeavors and moot court competitions and the like, we were sensitive to the fact that we start from a position of relative ease of compliance, and we should not dilute that further. That's really what's behind my concern. And again, I wouldn't want my remarks to be misconstrued in any way. I applaud the efforts of the pro bono committee, and I understand the judicial branch's objectives here. I'm not arguing against the merits of that at all. I simply have a problem here with the threshold issue of diluting further the MCLE requirements, and I'm not trying to persuade others who support this, because I understand its value. I just have to be candid in my own in my own evaluation. I hope that makes sense.
Could I follow up on Lou's comments, Mr. Judge Clow?
Yes.
There may be a way to, I'm not sure it's possible given the way the proposed rule is currently written, but there are certain circumstances where I think the fundamental goals and precepts of MCLE can be satisfied through this program. So for example, let's say Greater Hartford Legal Aid is having difficulty finding attorneys to represent women in restraining order cases, domestic violence cases, in family court, or CPOs in civil. And they do a training, a 2-hour training to teach people how to represent a client. Or same thing, the Greater Hartford Legal Aid is trying to find people to help folks in housing court, and they do a training. To me, that kind of training is very consistent with our the goals of CLE. But then once you get the training and you're representing someone, that's where I think the point that Attorney Pepe is making becomes stronger. So I don't know what I'm saying is consistent with the rule as written, but I can see opportunities for encouraging CLE pro bono through training that would get CLE credit.
Judge Clow, this is Lou Pepe again. I think you speak directly to my point. By the same token, my objective here is not to upset the apple cart. I mean, the Rules Committee, Judicial Branch, Elizabeth, all have been working around this rule with a certain concept in mind. And, you know, I don't want to come in as the dog in the manger here and upset it all. But the point you made, Judge Clow, goes to exactly the point I was trying to make, which is there's legal education and then there's pro bono. At some point, they intersect, and your example was one of them. But I still view them as two independent obligations the profession has.
And then just to your point, one of the reasons we don't mandate pro bono work it is certainly encouraged in the rules of professional conduct, is that there are a number of lawyers who are not permitted to do pro bono work. Public defenders, state's attorneys, a number of government lawyers. They're not allowed to do pro bono work. That when they take their job, they have to do that exclusively. And so if you, I mean, there's also a 13th Amendment argument, I think, that gets bandied around whenever states talk about making a mandatory pro bono requirement. But I think you're right to sort of point out, well, this is kind of our way of saying, we really think you ought to be doing pro bono work, and we can at least shoehorn it into the MCLE rule. Not as good as making a rule that says you have to do pro bono and tell us what hours you're doing, but a way to acknowledge that pro bono is important, and really it ought to be mandatory as well, as you have indicated, but we can't force attorneys to do that. So just in terms of why do we have an MCLE rule, but we don't have a mandatory pro bono rule, I think there are just a number of problems with forcing it, as well as people who would say, you did a bad job for me because you were forced to work for me and you didn't really want to take on that work. But you can take those comments for what they're worth.
No, Judge, this is Pepe. Quite frankly, I didn't think of that. I didn't realize those attorneys in the public sector could not or would not be allowed to do that. I didn't think about that. I don't know that I'm impressed by the 13th Amendment argument, but I didn't stop to think about. I always wondered why it wasn't mandatory, and you've educated me on that.
Judge Stewart?
Attorney Pepe, when I got asked about this during my hearing, my immediate reaction was the same as yours, and I'm sympathetic to your argument, because I do think, particularly based on what I've seen now that I've become a judge, that there is a need for mandatory regular education. And I also think there's a need for everyone in the bar to provide pro bono representation. But I got the impression from Representative Stavstrom when he asked me the question that he feels strongly that, at least from his personal experience, that he has learned more from doing some of the pro bono matters that he's handled, and has observed this from his firm, than, you know, from simply tuning into a PLI course. And there's something to be said for that hands-on learning that you do in a pro bono case. I mean, for example, I, and I'm sure many of the people in your firm, was recruited by certain federal judges on a couple of occasions to represent prisoners. And that was an enormous amount of learning on my part. I did not know any of the law, and that I'm certainly comfortable going into federal court, but you know, that was a big learning curve. So I can appreciate where he's coming from.
Understood, Judge. I appreciate what you're saying. Thank you.
If I may, Elizabeth, and thank you, Judge Stewart. I wanted to go back to Judge Klau's point. The predicate educational measures taken by an attorney that wants to perform pro bono services. If we have in this, the way it's written, that legal services are provided under the supervision of a recognized pro bono provider, prior to every time that an individual goes through pro bono service, is this educational basis provided before we're throwing, you know, before the attorney jumps into a particular case or service? Is there a, I'll call it mandatory or predicate 2 hours or 4 hours where the attorney is learning that craft before they're performing the service?
I'm not sure that there is, Larry. I'm just thinking of a case that was referred over by the veterans group. It was, and I think it was, there was a question as to whether or not, and it was sent over here to Pullman, and I think the question was whether that was something we could handle, and I think that the answer was yes, but there wasn't a predicate, course that went along with that, that I know of. So I'm not sure about that. Elizabeth, Judge Stewart may know more about that than from the pro bono committee.
Yeah, I don't think there is, but maybe that's something we could clean up in our FAQs and encourage that as part of our commentary on what the pro bono rule would allow lawyers to do. Indicate that there ought to be some learning component. It may be just a reading component too. I know we have had lawyers do trustee work for us pro bono when a lawyer is suspended or disbarred, and we would give them guidelines and then provide them with resources from my office and from the disciplinary counsel's office that they could contact us, they could work with us, they could show us their pleadings, and we would work with them to improve anything that needed to be tightened up before it was filed with the court. But we wouldn't give them a formal class on how to be a trustee.
And considering this discussion, does the commission have any comment in terms of the number of hours that we would be comfortable offering based on the totality of our discussion here?
I'll just comment as to the hours. What we've seen is, as I kind of alluded to earlier, people that are doing pro bono work now, either doing, just very brief, show up for a clinic or type thing, or they're way into it and they're doing far more than 12 hours. There's people who I alluded to the representation of prisoners cases in federal court. There's people that I can name that have done a number of full-blown federal jury trials. And And then as to the training, there are certain organizations that do provide for when you're first handling a child case or whatever it is, a brief training, but the most of it is what Attorney Rowe just described. They don't have the time. They're stretched so thin to do classes, where you're sitting there and someone's instructing you. It's mostly self-study materials that they've provided. I mean, they're usually pretty high quality, but they simply just don't have the time to be having classes.
Judge Facetto, I see we're reaching the end of our meeting time. Did you want to take a vote on this?
Judge, you're on mute.
You're on mute, Your Honor.
Sorry about that.
Yes.
So I think that's a good idea, Attorney Rowe. I would recommend using the language as modified by Attorney Rowe. And I believe that's on, again, page 4 of the packet that she provided. Now, correct me if I'm wrong, Attorney Rowe, but that would be modifying practice book section 2-55 subsection E in parentheses, subsection 8, by providing uncompensated legal services for clients unable to afford counsel under the supervision of an organized legal aid society, a state or local bar association project, or a court-affiliated pro bono program.
Judge, did we
Yes.
want to, Your Honor, did we want to modify that to Connecticut and making that state specific?
I think that's a good idea. So I think we would add
After the word organized, the word Connecticut.
organized Connecticut. And then the second would be modifying, is that section 4, Elizabeth?
So it's practice book section 2-27 capital A subsection C4 to create a separate category to explain the credit for, and that would be credit for the uncompensated legal services provided pursuant to subsection B8 shall be based on 1 hour of credit for each 2 hours of uncompensated legal services. A maximum of 6 hours may be earned during a calendar year. And then that would also just change the numbering going down from there.
All right, so do you want to vote? Well, we'll vote on it as a whole, I think.
So I'll second the motion.
All right, so all those in favor?
Aye.
Aye.
I,
Should I do a roll call on it? Because I think it might be a split vote.
Yes, yeah, thank you.
All right. Attorney Yuri? You're yes?
Yes.
Judge Clow?
yes.
Judge Stewart?
Yes.
Judge Murphy?
Yes.
Attorney Maurizio?
No, and I'll qualify it as to how the rule is written and with respect to the number of hours permitted.
Attorney Pepe?
Opposed?
Attorney Payne?
Yes.
And Judge Facetto?
Yes.
Okay, looks like the ayes have it. We have a vote. 1, 2, 3, 4.
All right, so what I'll do, or I'll have the Chief Court Administrator, Judge Bizzuto, send a letter to the Rules Committee. And I want to thank you all for making yourselves available on such short notice. I appreciate that. And I want to thank Attorney Rowe as well for her work in such short order. I appreciate everyone's attendance. Thank you.
Thank you, everyone.
Thank you.
Thank you.
All right.
Bye.
Thank you.